I'm Carrie Wood-Enertson. I'm the Senior Director of Government Affairs here at SAG-AFTRA. In my role, I advocate at the state and federal level on a variety of complex issues affecting SAG-AFTRA's membership nationwide. This includes child performer protections, state production tax incentives, right to work, sexual harassment, and many more. That's a little bit about me. I'm very honored to be the moderator of this panel tonight. Welcome to our Facebook Live event. We're going to be discussing California's Child Performer Protection Act. This is a law which requires many professionals who work with child performers, including publicists, hair and makeup artists, acting coaches, etc., to pass a background check and obtain a special permit issued by the state of California. So, to reach us during this event, you're going to want to email agency@sagaftra.org. That's where we'll be taking questions for the panel. They will not be taken on the Facebook page. So please send your questions to agency@sagaftra.org. And without further ado, let's get the conversation started by introducing our esteemed panelists. First, we have my boss, Duncan Crabtree-Ireland, a man of many accolades. Duncan is the Chief Operating Officer and General Counsel of SAG-AFTRA. He's responsible for broad operational oversight of our collective bargaining and contract enforcement for all of SAG-AFTRA agreements. Duncan is co-chair of the Board of Trustees of the AFM and SAG-AFTRA Intellectual Property Rights Distribution Fund, member of the Sound Exchange Board, delegate to the International Federation of Actors, known as FIA, and he teaches international law as an adjunct professor at USC Law School. Welcome, Duncan. Thank you for being here.
Thank you for having me, and thank you for moderating this panel, Carrie. It's exciting to be here.
Yes, thank you. And next we have Mark Lambert. Mark is a former deputy city attorney, recently retired from the LA Attorney's Office, where he worked for 31 years. For the last 23 years, he's been in the Consumer Protection section, and he was a leading prosecutor of talent scams. He helped write AB 1319, the Talent Scam Protection Act of 2010, authored by now LA City Councilman Paul Krikorian. He worked closely with SAG-AFTRA on this bill and to secure this passage. He also helped write and pass the Advanced Fee Talent Act of 2010, authored by LA County Supervisor, child actor, and SAG-AFTRA member Sheila Kuehl. So thank you, Mark. Thank you for being here.
Thank you for inviting me.
Next, we have Patricia Salazar. Patricia is a staff attorney with the California Labor Commissioner's Office in Los Angeles. She works on a variety of matters, including litigating cases in the area of wage and hour law, serving as a hearing officer in talent agency cases, public works debarment cases, and client-employer cases. She advises staff from the from the Labor Commissioner's Long Beach and LA district offices on a variety of employment case related. And she also advises the Labor Commissioners on AB 633, which is the garment unit bill. So welcome, Patty. Thank you for being here.
Thank you for having me.
Yes. Next we have Elizabeth McLaughlin. She's been a working actor since she was 14. Elizabeth McLaughlin has played dozens of roles in theaters and on the big and small screens. Some of her notable roles include The Click, Pretty Little Liars, Betrayal, Lethal Weapon, and Amazon's Hand of God. When not working, she's active within SAG-AFTRA, serving on the National Board of Directors and the LA Local Board of Directors, and has chaired the National Young Performers Committee since 2011. She is currently filming a recurring role in the upcoming series Grand Hotel, and was recently named the Rising Star by the Palm Springs Women in Film and Television, honoring women who break the glass ceiling. Thank you, Elizabeth. Thanks for being here.
Excited to be here. Thank you.
Yes. And last but certainly not least, we have Daryn Simons. Daryn is a talent manager, producer, digital strategist, entrepreneur, and the current president pro tem of the TMA, which is the Talent Managers Association. Daryn has won the Heller Award for Talent Manager of the Year in 2015, and has produced the last 3 Heller Awards with Sharon Stone, Joan Rivers, Betty White, and William Shatner. Prior to management, she worked in development and production at various studios, Paramount, Sony, and Fox. She's also a member of Children in Film, Film Independent, and Women in Film. Some of her recent productions include, sorry.
I was too long, sorry.
This is great, this is the best part. Nelson Bigsby takes on the whole wide world for Disney, locating Silver Lake and she has just locked print on the feature of the debt collector. Thank you, Daryn. Thanks for being here.
Thank you so much for having me.
Yes.
I'm really excited about this whole process.
So thank you all for being here and for watching online. Again, I'll just say, if you have any questions for this panel, you're going to email them to agency@sagaftra.org. And we also have kind of a fun interactive activity for you all. So let's get this started with our first sort of question. I think we'll go to Duncan, and that is, can you just describe the law, how it came into being, who's required to comply, who's excluded, how these decisions are made, and anything else you want to add?
Well, that's a nice, easy question. Thank you for that, Carrie. Well, I think maybe what we should do is start out by explaining, if it's okay, to people how they can participate in this little interactive part of this presentation. And we should probably start by saying, if you're watching this recorded, in other words, if you're not watching this live on Facebook right now, then you will get to observe us doing this interactive part, but you obviously won't be able to do it live because we won't be here once this is over. But if you are watching on Facebook Live right now, then you can participate. And we're going to have a few different sort of questions we want to ask you to respond to. And those questions are related to what we're going to be talking about. So if I talked about it first and then put the question up, that wouldn't be nearly as much fun as I think doing the question first, and then we can maybe talk about the answer. And of course, no Googling. I know you're going to Google it, but don't Google it. Just try to answer off the top of your head and see what you do. So first of all, the way that you respond to this, obviously you're on some type of a smart device if you're watching this on Facebook Live. So what you'll need to do is open up a browser window, unless you happen to have this app already installed on your mobile device, which is also fine. But go to any browser window on your device or on a separate laptop or whatever. And you'll go to pollev.com/SAGAFTRA. That's pollev.com/SAGAFTRA. No hyphen in the SAG-AFTRA in this case, so just SAG-AFTRA. And this will be on the screen when the question comes up as well. So you'll go to that web address, and you will basically be presented with the questions that we're going to ask. And so you can leave that window open throughout the course of this presentation, and whenever we get to a new question, it'll just pop right up in that browser window for you. Or if you happen to have the Poll Everywhere app on your mobile device already, you can just go to SAG-AFTRA, SAG-AFTRA, and the questions will pop up for you there. There's also a way to text in your answers, but I think under the circumstances, since we're on Facebook Live, probably no one needs to actually text them, but when we put the screen up, you'll see there's a way to do that if you want to do that as well. So maybe what we can do before we launch into the discussion of how this law started and when this law started is ask everybody out there, when do they think this law, the Child Performer Protection Act here in California, first took effect? And so hopefully you will now be able to see the screen with this question on it. The question is, when did the CPPA, that's the Child Performer Protection Act, that's what we're talking about here tonight, take effect? And your answer choices are A, 1912, B, 2009, C, 2013, or D, 2015. So basically, you just go to pollev.com/SAGAFTRA. You then will be presented a choice of A, B, C, or D. You pick your correct answer. See, there's no Googling. And then in a few moments, we should see you showing up on the screen. And I'm actually going to give it a little try myself just to, so that I can get in there. And I think one of these should be a fairly easy freebie. So we'll see if anyone picks that one. Hopefully not, but. And that's, okay, we've got our first answers in there, and the percentages will change live as people are responding to the question. So the question is, when did the Child Performer Protection Act take effect? And the answer choices are A, 1912, B, 2009, C, 2013, or D, 2015.
This is so cool.
And and yes, you are allowed to change your answer. So if you see them continuing to adjust as going up and going down, then you'll know that's why. It's because somebody has changed their mind after seeing what everybody else picked, which it's understandable. What happens. And so I want to make sure I get to get my vote in as well,
Tricky.
which I haven't done yet. So. All right, so it looks like people did pick up on the freebie there. Yes, 1912. If this law had started in 1912, hopefully we wouldn't need to have a panel on it in 2018 to explain that it exists and that people should be complying with it. So yes, it looks like 42% of the people who've responded so far have said B, 2009. 25% said C, 2013. And someone else just answered. So now we're tied at 2013 and 2015. So that's an interesting response. For those who are fans of that, of the sort of ask the audience type of thing, usually that works out pretty well. In this case, it did not work out so well because the correct answer is in fact now the least popular answer except for 1912, it's C. This law took effect on January 1 of 2013. That's our first slide. So getting back to the actual question that you asked though, Carrie, which is sort of what was the genesis of the law? The purpose of the law and the reason that the law was drafted and enacted was because it became clear over time from complaints to SAG-AFTRA, from complaints to law enforcement, government regulatory agencies and others, that there was a problem, certainly not with respect to most people who work with children in the industry, but there was a certain subset of people in the industry who probably shouldn't be working with children. And there was no good way to make sure that children were protected from being put in positions of having to work with people who really shouldn't be working with kids. For example, people who have past convictions for inappropriate conduct with minors, things like that. And there was no system in place to ensure that that parents and that employers and others could kind of keep children safe from that situation occurring for a lot of reasons. Partially because of the way the industry works, which is there's a lot of people who are employed by a lot of different people who work together on a project. In part because some of the people work on a project only for a very short period of time, and so they aren't there for very long. Things like that. And so once it became obvious that there was a problem and reason for concern here, the stakeholders who were interested in trying to fix this problem came together and thought that a good way to approach this, at least as a starting point, would be to put a system in place for people who are going to be working with kids in an unsupervised setting, perhaps, for example, and who weren't already getting licensed and being fingerprinted and things like that as part of their regular occupation. Doing that would need to get a permit, and the main purpose of getting that permit was so that they could be background checked and so that their fingerprints could be taken and they could be checked against the databases of people who have criminal histories that might make them unsuitable for those types of roles, those types of jobs. And so with that sort of concept in mind, a variety of people got together and worked on putting together this law, which you, I think, very capably described. And so what the law, in essence, there's a lot more detail to it, but in essence what the law requires is people who work with kids in the entertainment industry in certain specified types of functions need to get a permit in order to do that. And as part of getting that permit, the Labor Commissioner's Office conducts a background check on them, including fingerprinting, and then issues them a permit. And that is basically the fundamental concept. There's a lot of detail to it. The law lays out specifically what types of activities make you somebody who needs to have a permit. It also specifies certain types of people who don't need to have a permit because maybe they already have a license, they've already been background checked in other ways, and things like that. But the core element is, if you are someone who works with kids in the entertainment industry, doing a whole bunch of different types of activities that we'll talk about, I think, a little more, I'll give some other people a chance to talk, then you need to potentially get one of these permits before you're engaging in that activity, and maintain it, renew it every so often, and keep it up to date. And that is part of us all being responsible and helping to protect the kids who work in the industry from the kind of risks that they shouldn't have to face just because they're working in the entertainment business. So I think that's sort of my very long, short answer to your question.
Great. Well, just sort of tailing on that, we here at SAG-AFTRA, there's a rich history of trying to pass legislation to protect minors. And I thought maybe Elizabeth could talk a little bit about this history, how SAG-AFTRA became involved in it, and this particular law, and just your experience in the Young Performers Committee, and how that's gone.
Yeah, absolutely. SAG-AFTRA has always been instrumental to helping and protecting young performers. We actually make up a very large percentage of the membership, and that's any performer under the age of 18. And often they are the performers who obviously need the most protecting, and SAG-AFTRA has always been instrumental in providing that as much as possible, with aiding things like the Coogan Law and things like that. Within AB 1660, the CPPA that we're talking here about, SAG-AFTRA worked together with a wonderful organization called Biz Parents. They were co-sponsors of the bill, and I believe it took about a year and a half or so from kind of the inception of writing and lots of arduous hard work towards this bill being passed and going up to Sacramento and lobbying for it. And then it being passed in, I believe it was 2012 or 2011? 2012 is when it was passed? Yeah, so it went into effect, in, as we saw, 2013. Yeah, so.
Okay, great. And I think maybe Mark might be the best person to answer this. This next question is about any legislative or political challenges to passing the law. And can you speak to the process of how this was shepherded from inception through the legislature and ultimately signed by the governor?
Well, I mean, you know, the city attorney's office, we actually did not have anything to do with passing this law. We obviously support it. I have been involved with other legislation, which is like the Krikorian law, which has taken effect. And it was no different. Basically, my understanding is in 2011, Biz Parents Foundation was the first sponsor of this bill and helped write it. And Assembly Member Nora Campos authored the bill. And as with all legislation, it went through various rewrites. It went through committees. There were public hearings. It went through the Assembly. It went through the Senate. There was a chance for public comment. There was a chance for all interest groups to take part in it, to refine the language. And so by my understanding is that it passed with almost no opposition, both houses, and that the governor signed it in September of 2012, and it took effect in January of 2013. And you know, this is a really, and also again, my understanding is that SAG-AFTRA was one of the major supporters of this legislation, as was almost everyone in the industry. I understand the MPAA and Talent Managers Association, Talent Agents Association, PORAC, which is a police group, and others supported this legislation because it's so important, and so it seems so obvious that parents get to know, you know, that their children, you know, are not basically being represented or, you know, having services provided to them by persons who are sex offenders. And so this is a very simple piece of legislation. It's not unique to the entertainment industry. It was just necessary to be in the entertainment industry. If you think about it, schools, teachers are required to go through fingerprinting. Camps are required to go through fingerprinting. People who provide child services are required to go through fingerprinting. Soccer coaches, you know, club soccer coaches, club sports. So this is just a very obvious thing that needed to be done, and it's very simple. Do you want me to explain a little more about the legislation?
Sure.
Yeah. So basically, very simple, which is it's basically this. If you represent an actor or artist, which is more broad than just actor, if you represent one that's under 18 years old, or if you provide a service for a fee to that artist, and that fee can be paid by an artist or on behalf of an artist, then you are required, very simply, to go get a permit from the DLSE. There are exceptions. The main exception is for talent agents and those who work under a talent agent license, and the reason for that is that talent agents have to get fingerprinted and get a permit through 1700 of the Labor Code, whereas others who are required to get this permit, they're not required to be printed. So that's why you have this group, which includes managers, photographers, career counselors, publicists, acting coaches, those who provide a summer camp for artists. It's all very clearly spelled out in this Labor Code section 1706. If you fall into that group that's defined there, very simply, if you fall into that group and you charge a fee to an artist or on behalf of an artist, you have to get a permit. And it's a crime if you don't.
Okay, sort of continuing on that discussion, Patricia, I wanted to just see, since you're from the Labor Commissioner's Office, first of all, what the penalties are for noncompliance, and what happens to those who fail to comply.
So under the Labor Code, any person who fails to comply with 1706, and maybe Mark can also chime in if I'm missing anything, is subject to up to a $10,000 fine and or 1 year of imprisonment. And my understanding in speaking to our licensing and registration unit is that we've not received any complaints directly about noncompliance, but if we were to, or hopefully we don't, but if there were complaints of noncompliance, because several people are compliant, but if not, we would immediately follow up on those complaints with the appropriate law enforcement agencies, such as the city attorney's office, the DA, or the AG's office, to make sure that people that have not been compliant are subject to the penalties imposed by the Labor Code.
Okay, and then does the Labor Commissioner's Office, in your experience, have all the resources needed to process permits, and are there any challenges in enforcement?
Generally, no. Our website is very user-friendly. We ask the public or applicants to allow for a 45-day window to process. Well, first of all, to review the applications, process the permits, and issue a determination as to whether or not there might be grounds for not processing a permit based on any information we may have received from the DOJ. And my understanding is that we were able to meet that timeline fairly successfully. And if there are questions from applicants, it's mainly more specific to their applications and questions they might have about the status of those applications.
Carrie, if I might just jump in to say, I think, one of the messages that's really important to come out of this panel tonight is this is a great opportunity if you're somebody who is covered by the law and who is not registered now. The time to fix that is before someone calls the Labor Commissioner's Office and files a complaint about you, or before it becomes an issue. You should, if you think you might possibly fall under this, go to the website, get more information, contact the Labor Commissioner's Office if you need to, and make a determination if you need to if you're someone who needs to have a permit. And if you are, get one, rather than waiting until something bad happens and you're in trouble for not having done that. And that's one of the reasons I think why we are all here is to help put out the word that this permit requirement exists. If you were supposed to have one and you didn't know, now you know. So you know how to get it, you know where to find it. It sounds like it's pretty easy to get one, and you should definitely do it, both because it's required by the law and also because this is part of what all of us can do together to help keep young performers safe. And that in and of itself is a goal that I presume we're all in favor of.
And can I just add, not only did I get mine both the first time and then when I renewed in about 2 weeks, but it's cheaper now. So the price has gone down. So anybody who's doing it now, you're lucky. It's like half the price of what I paid originally. So go and get it. It's very simple.
Yeah, our website, I don't know if now's the time to give that information. www.dir.ca.gov/DLSC. There's a tab that says labor law, and there's a scroll down menu that says, I believe, registration services, and you just go under the permits, and it's a very spelled out process. You fill out the live scan form, you submit your fingerprints at a live scan location, you pay a $198 permit fee. It's renewable every 2 years. And you file an online application, which I'm fairly sure, I believe it's 1 or 2 pages at most, and one page, and it's downloadable if people prefer to, fill it out by hand and mail it to the Labor Commissioner's Office.
Also, this morning I wanted to make sure that I reread the bill, which is actually very readable for people who don't come from this legal expertise background. And I actually just Googled the Child Performer Protection Act, and the first thing that came up was the application link. So it's the first thing that comes up. It's very easy. I also wanted to point out, because it hasn't been mentioned yet, that it is written within the law that these permits should be placed conspicuously for everyone to see. So for parents of young performers watching right now, it is important that if you don't see one, to ask for it. I think that's a very easy thing to do. Also, they provided a really wonderful resource, which I found this morning as well, and it's a database of those who have complied with the CPPA permits. And it's very easy. You just type in first and last name and maybe an address if you have it, and it'll give you a list of people who come up under that information. So it's very easy to also check from the performer's perspective as to who has these permits and who doesn't.
Can I just ask one question, because I know it's been coming up in conversation. So if you're currently managing children and then you eventually decide, you know what, I'm just going to stick with adults, what I just wanted to ask on our panel, is there a process, because as of now I don't know that there is, to then say I'm no longer going to have my child service permit because I'm no longer, can you opt out rather than the renewal coming up and then you being afraid, oh my gosh, if I don't renew it, I don't have my child service permit, because I know there was a stipulation that we saw that you know, if you were not in compliance after a certain amount of time, there could be a problem there or a challenge.
Well, I mean, I think if you know, as long as you've terminated your contracts with any minors, if you don't represent a minor, you don't need a permit. So you don't really need to opt out of your permit or do anything. If you're not representing a minor, you don't have to have a permit if you're a manager.
Okay, great. Thank you for answering that.
Okay, this might be a good time to do our next audience participation, if that works for you.
Sure.
Okay, I've kind of forgotten what the question was, so we're going to kind of all get to see it
And
together.
then we
but-
have a flurry of questions coming in
Oh,
from
do
our
we?
viewers.
Oh, excellent. Okay, well, let's ask them one, and then they can ask us some. Okay, so this, I think we can probably figure out the answer maybe from the discussion we've had so far. This law, which you can also look up, as Elizabeth said on Google, you can Google the full text of the law, though not to answer this question right now. Which of the following is expressly exempt from needing a permit under the CPPA? And the answer to this was actually given verbally by one of our panelists a little while ago. The possible choices are A, talent manager, B, camp counselor, C, licensed talent agent, D, attorney, or E, photographer. So which of the following occupations, I guess you could say, is expressly exempt? And that means explicitly in the law, it makes them exempt from needing a permit under this act. So please, feel free to answer.
I choose 1912.
We tried to make this easy. Okay, let's see. All right. Shout out for the attorneys in the room, I see. So right now, we've got 80% of the people responding, 83% are saying licensed talent agents, and 17% are saying attorneys. And so it seems like nobody is biting on talent managers, camp counselors, or photographers. And the talent agent one continues to grow. All right, so I think we can call this one, we can call this race for C, licensed talent agent. And the Ask the Audience was very successful this time. The audience got this right by a massive margin. I think Mark actually said it a few minutes ago, that licensed talent agents are explicitly exempt from this law, and he explained the reasons why that would be the case. What about attorneys, Mark? I mean, we've got a couple, at least 2 or 3 attorneys up on this panel right now. Attorneys aren't mentioned either as being covered by the law or exempt from the law, are they?
They're not.
No.
And I don't know the answer.
Yeah, but
Neither do I.
okay. So I believe I recall when we were going through this at the time that this is probably one of those things that was left vague on purpose. But I do recall some discussions about the fact that the type of oversight that the DLSE has, the DLSE Labor Commissioner also issues licenses to talent agents. So the same government agency is looking at talent agency license applications and also these permit applications. Obviously, the state bar issues licenses for attorneys. They do conduct fingerprinting, as any of us who are attorneys are well aware, but they're not really in the business of regulating the entertainment industry per se. So I think this may be one of the reasons why this is a little bit of a gap in there. At least if it were me, if I were an attorney who did a lot of representation of young performers, I certainly would consider just getting the permit just to avoid any issues on that side. But I think none of us here are saying it's required, but none of us are saying it's not required either. It's a little bit of a gray area still at this point.
And I think it's like you said, I think part of the reason this law might have been left broad for a reason is that if, like Mark said, if you're providing one of the required services for a fee and you happen to be an attorney, you're not necessarily excluded from having to file an application and get a permit.
That's an excellent point. So if you're an attorney, but you're also, for example, a talent manager, or a camp counselor, or a photographer,
Sure.
in any of those capacities, you would definitely be covered by this law, and your status as an attorney doesn't exempt you from that.
Correct.
And that's also good to know for us, because when we are referring our minors to not camp counselors, but to photographers and to different people, it's always good for us to have that in our list of everybody who's covered by this.
So we've got some casting directors watching. Thank you all for tuning in. They want to know, one, do they need these permits? And two, does everyone in the casting office need the permit? Directors, associates, assistants, etc.
That was also, glad you asked, because that was something I was going to ask, because that was the one thing that I thought noticeably was missing from the law, so I'm curious as well.
Anyone, are you gonna take a crack at that?
Me?
No.
I thought you were looking at me, I was like, I'm asking.
I was looking to your left.
You want to go over some
To
other
your
side,
Well,
maybe?
I mean, I wouldn't give out legal advice, I mean, but, I mean, I would say, a casting director does not represent a child artist. So the question is, are they providing services to the artist for a fee paid by an artist on behalf of an artist? So when you're just casting, when you're doing an audition of an artist, you're not charging them a fee to audition, so I would think the answer would be no. But if you are putting on a casting workshop and you are charging and charging minors to attend that casting workshop, then the answer would be yes. So casting a workshop that has classes for minors, for instance, would have to have this permit.
So a key element there is the question of, are you charging the person or are you being paid by somebody else to perform those services?
That's the way I read it when you look at the definition of fee.
And I also think you want to look at those specified services which are laid out in 1706. I mean, I'm not, maybe, like Mark mentioned, if a casting director has, well, my example maybe has a camp, right? Or in other words, it's hard or difficult to sort of take it case by case. I think that the better approach I would take is, if this question were fueled to the Labor Commissioner's office, is to look exactly at what type of activity is being done. Does it fall under 1706? And if so, and if there is an argument that this person should be permitted, then, as mentioned by one of my other co-panelists, get the permit in an abundance of caution.
And I would just echo that as well, if not only for the fact that, as so many of the people watching are aware, casting offices are really one of the only places uniquely where a child performer might be alone without parent or guardians, within the casting audition. So I think in terms of good faith and caution, I think it would absolutely be wise to do it. I think it also shows a very kid-friendly or young performer-friendly office to have complied and to conspicuously show the permit. I think that shows that the parents, at least upon signing in at the casting office, you might see that permit and know that your child is in good hands.
I think it's really important to note that what's in the law, and like you said, Elizabeth, earlier, it's pretty accessible. You don't need, a law degree in order to read it or understand it, at least in my opinion. But the law is really directed at activities, not at people, right? So it doesn't say, for example, personal managers need to have a permit. It says if you're engaged in managing or directing the development or advancement of the minor's career as an artist or performer, right? So it's not about the job title or the name that the person has on their business card or whatever. It's about what they're doing. And so depending on what you're doing, that will determine that. And really, to my way of thinking, the main exception to that is the fact that there is an exception, a specific statutory exception for talent agents who are licensed to do that. So that is sort of a job title in a way. But it's also what they're doing. If you're a licensed talent agent and you're doing other activities, then you may need a permit as well. If you're a casting director and you're doing other activities like we talked about before, lawyers who are also photographers, casting directors who are also photographers on the side, or whatever else they might do, if it falls under this type of service, then they not only should, but really have to get a permit. But I agree with our other panelists that in what we usually think of as a casting director's function, a pure casting director function, that doesn't fit into one of the categories of services that are listed here. But it's not choosing not to get a permit if you do anything besides that is at your own risk, really, because there's a lot of stuff that is covered by this law, right, and rightly so, in my view, anyway.
Here's another question coming in. Is the DGA included in this effort? So first ADs, directors, second ADs, third ADs be fingerprinted, background checked, and permitted? Somebody, I can't answer that.
Well, let me just say, no. I mean, basically, no. Unless the services that are being provided, this is really about services that are being provided to young performers. That's not to say that there shouldn't be, and that's not to say that there might be some circumstances where that would occur, but that's not the main focus of this law. The short version of that is not really. This law is focused on people who are providing services to the young performer. So as Mark described earlier, a casting director typically, in the traditional sense of a casting director, is not providing services to the performer. They are providing a service to the producer to carry out their casting function for the producer. And just like a whole bunch of other services that are provided as part of a crew on a set, that's not specifically part of these services in this law.
Also, just to piggyback off of that, I believe, if I'm remembering correctly, that there is a line statute in 1660 that says something about where a parent or guardian wouldn't have supervision of a child, which on set parents and guardians should have sight and sound of their child at all time. So I think that might have been one of the legal kind of specifications in order to cover that. Because a young performer should be within sight and sound of their parent and or guardian on set at all times. And I just believe that there's some tidbit in there that brings that up. So hopefully that helps.
That's absolutely right. Good memory. There is a specific exception.
Maybe I should go to law school.
We can talk afterwards.
Okay.
No, and to Elizabeth's point, or maybe, again, it really does boil down to the kind of activity in question and what exactly a certain position or person is doing, but there's also people or CPS permit is not required if a person only has incidental or occasional contact with an artist who's a minor, and there's very specific definitions about what that occasional or incidental contact with the minor would be, which includes being 10 feet away from the minor, who's not accompanied by an adult for no more than 10 minutes at a time, happening 2 times, no more than 2 times in a 7-day period. So that does sound very detailed. And what I would again suggest is if a person is thinking, well, do I fall into this requirement or not, think about the degree of interaction you have with a young performer, and again, in abundance of caution, if it's more often than not, then something to consider applying for.
Yeah, but again, going back, I think why this is such a good statute, the drafters of it, and again, I didn't draft it, which is why it's so clear. But why it's so good is it's very easy to say whether or not you are covered by it and whether or not you need a permit. All you have to do is go to the triggering portion, which is the definition of representing or providing specified services to a minor. They actually have that in the statute. Read that. And underneath that, they have the categories. And the only real exception is the talent agents and those who work under a talent agent license. Other than that, it says representing or providing specified services. Then they list the specified services. If you provide one of those specified services, or you represent the minor, you have to get a permit. And again, the triggering mechanism is if you charge them a fee. So if you charge the minor a fee for any of these services, then you have to get a permit. If you represent the minor for a fee, like a commission, you have to get a permit. So very, very well-written statute, just look there, and if you fall under it, you need to get a permit. And the question is, why wouldn't you? I mean, unless you're a registered sex offender, why wouldn't you, if you fall under this category, what are you waiting for? Because the truth is, at some point, there's gonna be some investigation. There's gonna be some undercover person going into, investigating this. It might be you. And if it is you, you're gonna possibly go to jail, you're gonna possibly pay a fine up to $10,000, which in our system means with penalty assessment makes it almost $40,000. You're gonna have to pay for an attorney, all that, and you could have avoided that by paying, a couple $100s and getting your fingerprint checked and going to the DLC and getting a permit. It just doesn't make sense not to do it. And I guarantee you, if enough people don't follow this law, there will be undercovers, there will be prosecutions, and then once there's a prosecution, everybody's gonna go get the permit, because it's just not worth it.
Well, let's also give a shout out to the one other category, just so they don't inundate us with feeling that we've forgotten them, which is studio teachers. Certified
Yes.
studio teachers also do not, in that capacity, need to get a permit. I'm correct about that, yes? I saw a lot of nodding, so I think
But
I'm right.
again, I was thinking, studio teachers don't charge the actors, right? They're paid for by the studios. So again,
That's true.
I think that's written in there just to make it clear. If anyone has a question, studio teachers aren't covered, just in case you can't understand the rest of the law. But studio teachers don't charge the actors, so they wouldn't be covered anyway.
And I believe they're fingerprinted as well
Yeah,
already.
they do go through background checks and accreditation separately.
Also by the Labor Commissioner's Office.
Correct.
And we have
See a theme here.
a question just came in for you, Patricia. Do you recommend people call the DLSE if they have questions about whether the law applies to them?
Absolutely. So I can there's an email and a phone number that you can call. The email is cpslicensing@dir, like Department of Industrial Relations, dir.ca.gov. There's also a number to call, which is area code 510-285-2123. 285-2123, and the person who I was given the permission to keep out their information. The person to speak to is Christopher Dooley, D-U-L-A-Y.
Also, this might be a good time to mention that I was told before the panel that all pertinent links and information will be posted immediately following the Facebook Live event, and so I'm sure we'll include that information.
That's really helpful, thank you. Next question I think is for Daryn. You've had many years of experience in the industry. Just wondering, what does your experience tell you about this law? Has it had a positive impact? Is there room for improvement? What's been your experience?
So I feel it's definitely had a positive impact. I think what we need to continue to do is get the word out, like evenings like this, and continue to talk to people. It was interesting when I was trying to renew my permit, because there was a little thing that we had to fix on the web, and actually I called up. It took about 2 weeks, and we worked on it together, and now we have a renewal button. So I felt like, yes, we all did it together. But I just think that the word isn't getting out there, or people are not paying attention to it. So you need to wake up. It just, for my clients, for their parents, it's just peace of mind. And when we first sit down and have that conversation, and I tell them about this, they feel relieved. They're happy to know what's going on, and they just are a little bit more educated about the process. So again, it's just continuing to spread the word and make sure that everybody knows how important this is. These are minors, and we're just trying to keep them safe.
Thank you. So another question came in from a personal manager, and I'll just read it, and it's about a little snafu that they encountered, and whoever would appropriately respond. They said when they went to renew the permit, they were told that it was too late, had to renew 60 days before its expiration, not 15 days. as they originally thought, and because of this, they were told they'd have to pay a $10,000 fine, regretted signing up, eventually got someone on the phone to help, but made them very nervous. So does anybody want to speak to that?
Can I just say one thing, because I know a little bit about this. I believe now that it's much more streamlined. When I just went in to renew recently, pick up the phone, talk to them, explain the situation of what's going on, and they will work with you. Again, we couldn't renew, and it took us going back and forth and me using my password, giving them my password, and just having that conversation with them. So you just need to have communication. And everybody can lose track of time. It would be great if we had on the site, just to say, if we had some type of a reminder that would go out to the people that needed a renewal to say, you've got 6 weeks till you're, to renew. You've got 4 weeks, because we all, say, oh my gosh, I completely forgot. But I think if there was a reminder that was coming back to us, I think that would be a benefit.
I think, don't quote me, I think the website has, I know our website has very useful and informative FAQs, and I believe the information regarding timing, if you're a renewal applicant, is on our website. And certainly, as you mentioned, Daryn, call. The number, we gave out the number, and I again, to your question, or the question about whether we have the resources to answer questions and review the application process. I mean, my understanding is that we're able to meet that timeline very successfully, but certainly there are snafus and holdups in specific applications, and if that happens to be one's case, then I would definitely suggest that you call and follow up to see what may be the holdup.
Okay, so we have one more small snafu while we're on this vein, from a personal manager who wrote in, and I'll just read what they wrote. I was at the forefront of applying for the permit when the law was passed. And can report there were some technical issues, which I think, Daryn, you just said that those have been ironed out.
Yeah.
Passwords not working, problems with the sign-up process. They want to know if the technical parts of the sign-up have been addressed, and I think you just pretty much answered that.
I'm happy, yes.
You're happy? Okay, great. One more person wrote in, asking why they should comply with the law when so many aren't. And there appears to be no repercussions for not doing so, which I think Mark's mentioned that there will be, ultimately. Once I comply, I'm in the system and held to a different standard than those outside of it. Are you planning to start real enforcement of the law, and is it a resources issue? Again, I think a lot of this has been addressed by Mark, but if anybody wants to expand on it, that was a question that was written in.
Well, can I just say, I think you should comply with the law not only because of being afraid of what might happen to you if you don't. At least for me, that's one thing I want to say. It is, part of making sure that young performers are safe. Is making sure that everybody who's working with them, particularly in these types of roles, these types of capacities that are listed in the law, does their part. And when there is a sort of critical mass of everybody who has done this, who's gotten their permit, who's gone through the background checks, etc., then it's going to be a lot easier for parents and for others to use the search functionality, for example, that the labor commissioners provided, etc., to sort of vet this. So at least from my point of view, it's taken a lot longer to get people ramped up and obtaining these permits than it should have. But if you have any doubt that there's attention being paid to this, then this should help you erase that doubt. There have been press articles about this. That's, our concern is to get people to comply with the law, not to get people to get in trouble for not complying with the law. That's why we're trying to do proactive outreach from SAG-AFTRA, but it's not just about us. It's about everyone saying, look, people who are working with young performers, you just need to get the permit. And we've, it's been made clear it's not that hard to do. I would take issue with one thing that person said, which is, once you get the permit, you're somehow held to a different standard. I don't think you're held to a different standard at all. You're held to exactly the same standard. If you're working in one of these capacities with young performers and you don't have the permit, then you're breaking the law. If you get the permit, then you've complied with the law. That's it. There's no additional standard for how you interact that's part of this law that somehow doesn't apply to you if you fail to get the permit. So to my way of thinking, and I think others have said this already, you know, there's really no reason not to get the permit. I mean, there's a whole lot of reasons that you don't want to, you know, break the law about this, and getting the permit is pretty easy. It's not that expensive, and it's just part of doing business if you're in, for someone who's working with young performers this way.
And can I just say, if you don't want to comply with the law or you don't want to be in the system, then don't work with minors. I think it's as simple as that.
Okay, yeah.
I was going to add this too, which is another thing is as the word is spread that this is the law and these different groups have to get a permit. Parents shouldn't hire anybody who doesn't have a permit, and hopefully the word will get out. If you're a parent and you have a child in this business, if somebody you're looking at to be a manager for your child, you say, do you have a permit? Do you have this permit? If they don't have it, don't hire them. There's other managers out there. There's other acting coaches. There's other publicists. You know, there's other acting camps. You know, dance camps, whatever. Don't do business with them. And the thing is, it will help you if you get this permit. You can actually advertise that you have the permit, which is something that is a benefit to you and a reason people should hire you. I know of a case when I was in the city attorney's office. There was somebody who had a summer camp for actors, and they went and got a permit, and then they proudly advertised it on their website that they got one. And that was a selling point, a major selling point. So, you know, that makes parents feel good. So the other reason, besides the fact that it's a law, you should get it because it's the right thing to do, you know, is, you know, parents shouldn't hire you if you don't have it.
Has the Labor Commissioner's Office or SAG-AFTRA gotten feedback from parents, guardians, and even the minors themselves about the law?
I'm not aware of any feedback that the Labor Commissioner has received about the law. But again, I do think that part of our process, and keeping with what Mark said, is to encourage people to get the permit. The one thing that we also, you know, encourage, it's all with a view toward protecting the interests and the welfare of the young performer. And maybe, you know, silence is a good thing, and that if we're doing our job and we're processing the permits in a timely manner, that would be an incentive for people to continue to apply as they should.
Well, I mean, we certainly heard a lot about it when the law was under consideration and ultimately when the law was enacted. And certainly recently, some of the press coverage of the lack of getting permits on the part of certain areas of people who are providing these types of services has triggered some more questions coming into us about it, more concern on the part of parents. So I do think that, you know, to the point that's been made, complaints will probably, I mean, if there's been a sort of a honeymoon period where there's been time for people to get their license in order, et cetera, I suspect that honeymoon period is probably coming to a close. I think complaints will start to come in if people aren't getting these permits to the DLSE and possibly to local law enforcement, et cetera, and someone, you know, is ultimately going to take some action on those complaints. So really, I think, yes, parents are interested in this. I think parents, speaking as a parent myself, you know, you want to make sure that if you've got your kids working with somebody, whether it's a teacher, whether it's a, you know, forget the industry, if it's a teacher, if it's a coach, if it's anybody like that who's going to be around your kids a lot, you expect that there's been some sort of check to make sure that those people, you know, aren't registered sex offenders or don't have a disqualifying past criminal history, et cetera. And I think parents do expect that, and they're right to expect it. So, I think that's the truth.
Great. So we have another question that just came in, just for clarification. So if someone in Hollywood is working with children but does not charge a fee, they don't need the CPS, and doesn't that give bad guys a way around the law?
Well, I'll let the people to my left comment on that, but I will just say, I mean, I think when you interpret charging a fee, you should bear in mind that there are ways we've heard about in the past where someone might claim that they're not charging a fee when they really are. I'll give you an example is people who you know, put out ads and say, come interview with us because we've got, you know, we've helped connect people to these big companies and get them jobs on famous television shows, et cetera. And then when they show up, they get referred to photographers, they get referred to acting teachers or classes or things like that, and there is likely some money coming back to them from those types of referrals. I wouldn't be surprised at all to find to find a law enforcement agency making the argument that if somebody does something like that, even if the young performer, their parent didn't directly pay them money, if they're getting money essentially as a result of payments that those people are making for other services and kickbacks and things like that, they would be under the scope of this law as well. So again, but I think the key point that's made is why would you not get it? And what are you going to say to a parent who asks you, do you have this permit, or have you been background checked, or to the people who work for you, have they been background checked? I mean, this is actually one way that people can make that happen.
Yeah. So what can all of us do? So those watching and all of us here, what can we do to get the word out about this law and spread the word about it?
Well, I'll start. This is something that for any young performers or the parents who've ever heard me talk, this is, excuse me, kind of my main talking point, which is the best way to impact. SAG-AFTRA is only as powerful as its membership, and the greatest way to empower our membership is through education, and the best conduit to do that is through conversations. I know from when I was a young performer that the young performer community and the community of young performers' parents is one that is very close, and there are lots of message boards online and coffee hours and things like that where conversations are being had, where young performers and their parents have ways to ask questions with the people who are more experienced. Those are the places where this should come up. There's no excuse to not ask for this permit at this point and to protect your child, because as my fellow panelists have said, why would they not have one? And at this point, it's been many years, they should have one. But the best way to protect and to get the message out is to have those conversations and to know that you are empowered to ask to see the permit if you don't already. And maybe that's a reason to not go with said manager or said acting coach or photographer if they don't have one, and empower each other and know that there's not going to be any repercussion. A lot of times when my committee or our work here at SAG-AFTRA, we get a lot of enforcement issues, and these are things that are problems that have come up for young performers and their parents, but we find out about it too late out of fear of repercussion and things like that. And ultimately, it's your child's safety that's on the line, and there's a reason, unfortunately, that this law got enacted, and it's to protect future cases from things like that happening again. So empower each other, talk to each other. If you feel like there's a young performer and their parent moving from a small town to Los Angeles and maybe they don't know about it, spread the word. Spread it, educate each other. That's our greatest tool, I think.
So I think we're towards wrapping up, and I know that Duncan has.
Well, yeah, I think we should check and see if the audience is still with us.
Yes.
So maybe we should ask another question. Okay. Now, this one you should definitely know by now. What California government agency administers permits under the CPPA? This is a real test. A, the California Department of Justice. B, the Division of Labor Standards Enforcement. C, the Employment Development Department. Or D, the Secretary of State. So, Department of Justice, Division of Labor Standards Enforcement, Employment Development Department, or Secretary of State. I'm gonna answer what I think.
Thank you for watching one person.
Duncan.
Well, I just voted. But if everybody gets it right, it will still say 100%.
That's true.
So
That's
right.
For all we know, that's 50 votes or 100 votes. That's great. All right, so clearly the message has gotten through that is where you go to address any desire to have a permit, any questions about who has permits, the search features, etc. I think we have another quick one. Oh yeah, this is a good one. I think it's a good one. For purposes of the Child Performer Protection Act, a minor is a person under age what? What is the age where someone is considered a minor for this law? Is it 14, 16, 18, or 21? 14, and that wasn't me, I didn't answer yet, so I'm not saying if that's right or wrong answer, but is it 14, 16, 18, or 21? Any of our panelists want to tell the room what the correct answer to this question is? Besides me? Or if not, I don't want to put you on the spot.
It's 18.
It is 18. That is correct. Wow, 100% of the audience has gotten that
Can
one
I
right
ask
as
a really
well.
quick question? And it's definitely not 16 if they've taken their test fee.
Well, this does prompt that interesting question, but at least my reading of the law is that it nonetheless applies up till age 18. But I would have to ask Patricia if she has a different interpretation from the Labor Commissioner's office.
Thank you.
And I'd have to research that.
Okay. So presume it's 18 unless you've got really authoritative guidance elsewhere. And I think the truth is, for most people who are providing services to minors, if even one of their clients is not in that situation, then they're going to need the permit anyway. So, and for all the reasons we've talked about, as a parent, you might still hope that they would have a permit if they're engaged in regularly representing young performers. Okay, this one's really a tough question. I don't know if we've still got enough juice to answer it, but which of the following is not a service listed as requiring a permit, as requiring one of these permits? So, still photography, career advancement management, that's B, coaching at a day camp is C, directing a dance academy recital is D, or aptitude testing is E. So what I can tell you is 4 of those things are listed specifically as services. If you provide them, you've got to have a permit. And one of them is not, and it is in fact pretty clearly excluded.
I'm going to take how about directing a dance academy recital?
Well, it looks like we've got some people.
Oh.
Wow, we're all over the map on this one. So this is a good question to end on, perhaps,
Yes.
but not before we tell you the answer, of course. Because that would just be cruel. That would be cruel on our part. And it looks like aptitude testing is taking a lead. And Mark was about to say something. I heard it well.
No. Oh, I heard what you said.
Okay. So, well, my answer to this question is D, directing a dance academy recital, because there's a specific provision in the law that states if you engage in an activity such as that for a school or an academy, etc., that it's excluded. Now, I know we've got a whole discussion going on about, if you were directing a dance academy recital, would you be charging a fee? I imagine that there is a scenario in which you could be charging a fee, and in that case, this is listed as something that would be exempt. But clearly, just for anyone who's out there who was unsure, career advancement management definitely is listed as a service that if you're doing that, you've got to have a permit. Aptitude testing is also specifically listed as a service. If you're doing that for a fee, you've got to have a permit. So, so I think that's the answer. But if there's some discussion, Mark, you want to weigh in?
No,
I feel that
again,
you're
no,
thinking something
I'm not an expert. I didn't recall seeing a specific exception for dance academy recital.
Well, I think it's
And-
specific to schools.
And I didn't see one for schools either. I think the issue, and unless I missed it, and I could have, but if it's not specifically in the law.
So it's the use, exhibition, or employment of performers under 18 years of age at any church, academy, or school, including dancing schools, as part of regular services or activities or an annual graduation exercises.
Right.
So I think that's the exception that's what
Right.
that is meant to
But
be.
is that a FAQ or FAQ, or is that
I think
actually
that's in the
law?
second. That's in the second part of the law. It's pulled out of the exception section, I
Okay.
believe, isn't it?
It's also, it's also in the FAQ. I'd have to look at the literal language of the code to confirm that, but that was my understanding.
Well, so if you're directing a dance academy recital, double check. Call the Labor Commissioner's office.
Right.
Email them
Safe and
at the email address that Patricia
Right.
gave you.
But-
But if you're doing any of those other 4 things, then definitely, and a whole bunch of other things too,
Right.
that are listed in the law, then you should be getting a permit, right?
Right.
Yeah.
But if you're instructing on dancing, you do need to have a permit. It's for someone to be a professional artist, and that actually is in the law. So maybe the recital itself isn't, but if you're instructing on dance, it is.
Yeah, so it's good to err on the side of caution.
So it is time to wrap up. We just want to give a huge thanks to everybody who watched this panel and to all of our panelists. It was wonderful. Thank you so much for being here and coming. And good night.
Thank you, and thanks,
Thank you
Carrie,
so
for
much.
moderating.
Thank
We
you.
appreciate it.
Thank you.